I just want to say welcome to this very, very special program that we have this morning. And let me just introduce myself. I am Dick Blake, a member of Ollie's program committee. 2 months ago, Dave Musanti, our illustrious president that just spoke, and I discussed the possibility of inviting Erwin Chemerinsky to come to speak to us. And we both knew that it would be impossible to get Dean Chemerinsky to come to speak unless he had a reason to come. Well, it turns out that I made one email to the right person, and that right person, that did it. And so we have our Dean Chemerinsky with us here this morning. And that one person is our own Rafe Sonnenschein. For the few of you in the room that may not know Rafe, he is a professor in the political science department here at State Fullerton. And it turned out that Rafe and Erwin are very close personal friends and have known one another for how many years about? Don't ask. A lot of years. So, Rafe, come on up and introduce our guest speaker this morning.
Good morning, everybody. Great turnout. I told Erwin that he should think of this as speaking to a synagogue audience. Those members of synagogue audiences know what that's like. It's the kind of audience where you make a historical reference and people actually know what you're referring to. And they will be happy to correct you immediately. So it's like a law school class with a lot of experience. So you can do that. It's just a tremendous honor to be here and to be able to introduce Erwin Chemerinsky. I want to thank a lot of people who made this possible. Dick Blake from Ollie, we should give a round of applause to. Our work to put this together. Our Division of Politics, Administration, and Justice is here in force, both faculty and staff. We've closed the office for the 2-hour period this morning so the whole staff can be here. Where's our staff? There they are. That's our hard-working staff. Our faculty are here. We also have the third sponsor of this is the Pre-Law Society. Gotham Aurora, where are you? Where are you, Gotham? Are you here? Max, where is he?
I think he's in the overflow room.
There is an overflow room. So if you're in the overflow room, Gotham, stand up. Let's have a round of applause for the non-existent Erwin Chemerinsky got his Bachelor of Science from Northwestern University. I particularly know that because it turns out he was in my wife's class. She didn't know that at the time, except when we looked up her graduation record, the #1 student in the university was this guy named Erwin Chemerinsky. So it's a long arm of coincidence. He got his JD from Harvard Law School and began teaching at DePaul College of Law, which is where I first heard of Erwin because just about his best friend was my brother David, who's a law professor there and now a law professor at Temple University. And he always used to tell me Erwin stories that were just loads and loads of fun. To my great joy, Erwin moved out to Los Angeles in 1983 to teach at the University of Southern California Law School. Then I got to know him quite a bit better on my own. And then in 1997, I began to work with the appointed Charter Reform Commission in Los Angeles, and Erwin was the chairman of the elected Charter Reform Commission, which was made up of 15 people elected by district, and the largest number of votes in that election was received by Erwin Chemerinsky in the 5th Council District. He was a huge force in making charter reform succeed, and in also creating the notion that you can't mess with a professor. A couple of times, Mayor Richard Reardon, who was a rather powerful fellow, tried to slap Erwin around in the metaphorical sense, not in the literal sense. And my most famous line from Erwin, which he may or may not want me to repeat, was, "If you've got 8 votes to knock me out, use them." I'm from New Jersey. I find that to be just the way to talk to someone who's exceeding the boundaries of their power. And needless to say, the mayor of Los Angeles did not have 8 votes to drive Erwin out. And as a result of Erwin's commitment to working together, a charter was created between the two commissions that became the first revision in 75 years of that charter. And that was actually a sidelight for Erwin. Most of the time he writes books. His most recent book is out there for sale. And our bookstore, by the way, in order to make it easy for you, put a little discount on, so with tax, it's exactly $20. None of this little messing around stuff. No checks, cash, or credit cards. But it can be exactly $20, which I think is rather nice. After Erwin is finished, he'll sign books in a room back right behind this room. He's written 7 books, 200 law review articles. He writes columns, but mostly he's a practitioner and teacher. He argues appellate cases before the U.S. Supreme Court, which in many ways you'll see as the framework for this book, is the story of what happened when Erwin would bring cases before this particular Supreme Court. He's been named in 2005 one of the top 20 legal thinkers in America. He's routinely listed as one of the most influential lawyers in California. And he's called upon by government frequently to advise them in difficult situations. The city of LA asked his advice to do a report on contracting, and he did a very well-regarded report on the Rampart scandal. Basically, to put it in a nutshell, Erwin is one of those people who has a first-class mind, a first-class set of commitments, and an ability also to get things done in the real world. And I believe that our having him down the street at the UC Irvine School of Law is a tremendous asset for our university and for our community, and I hope someday for our law students. How many of our law students are here? I'll give you the address of the Department of Admissions at UC Irvine Law School, and we want you keeping your sights high and thinking about being in one of his entering classes. The way we're going to go is I'm going to introduce Erwin to speak. He will then take questions. I've alerted him it's always good to repeat the questions so everybody can hear. As to questions, may I ask you to remember the definition of a question? A question is a phrase that ends with a question mark with a slight uptick in your voice as a question. A question is not, dear Professor Chemerinsky, I have 45 things I've thought about my whole life, each of which I think you should respond to, but first allow my speech to continue. So we will try, if we can, to have an actual Q&A, not an S&A, speech and answer. And I'm sure we can do that. With no further ado, let me introduce Erwin Chemerinsky.
Rafe, thank you so much for the incredibly kind introduction. It's really an honor and a pleasure. As I was listening to Rafe, I was thinking, I think it was Harry Truman who said, if my father were here, he would enjoy listening. If my mother were here, she would believe what you said. I don't want to seem an ungracious guest, but I do want to disagree with one thing that Professor Blake said, and that's anytime you invite me, I will come. It's really my honor and pleasure to be here. And certainly any time that Rafe invites me, I will come. I once heard that you don't need many heroes if you choose your heroes wisely, and Rafe Sonnenschein is one of mine. He is one of the leading experts in urban government. There wouldn't be a new charter in Los Angeles but him. And he's done such an amazing job of teaching generations of students here in political science and government. My client, Leandro Andrade, is sentenced to 50 years to life for stealing $153 worth of videotapes from Kmart stores in San Bernardino, California. He received this sentence under California's 3 strikes law, even though he had never committed a violent felony. California is the only state in the country where a person can receive a life sentence for shoplifting. In fact, until California adopted its 3 strikes law, no one in the history of the United States had ever received a life sentence for shoplifting. Andrade is an Army veteran. He became addicted to heroin when he was in the Army. Not long after his discharge from the Army, he was caught breaking into 3 unoccupied homes. He was sentenced to 2.5 years in prison, and he did serve the entire sentence. Over 10 years later, he got caught stealing videotapes, all children's videotapes, from Kmart stores. The prosecutor had a great deal of discretion as to what to sentence Andrade for. He could have been sentenced for 1 count of petty theft, that's up to 6 months in jail, or since he did it twice, 2 counts of petty theft, that's 1 year in jail. Or there is a felony in California called petty theft with a prior. That means if somebody is committed and been convicted for a prior property offense, they can then be sentenced for petty theft with a prior. One of the many ironies of this story is that Andrade's prior crimes had been rape or murder. His maximum sentence was 1 year in jail. But because of his prior offenses being property crimes, he could be sentenced for 1 count of petty theft with a prior. That's a maximum of 3 years in prison. Under the strange sentencing structure in California, had he been convicted of 2 counts of petty theft with a prior, his sentence would have been 3 years, 8 months in prison. The prosecutor could have sentenced him, and had him sentenced by the judge, for 1 count under California's 3 strikes law, 25 to life. But instead, the prosecutor decided to seek the maximum sentence, which was the prosecutor's policy always in San Bernardino, and that was a sentence of 50 years to life. At the time I argued his case in the United States Supreme Court, CBS's 60 Minutes 2 decided to do a story about it, and Dan Rather actually got into the prison to interview him, and 60 Minutes 2 found some of the jurors who had convicted Andrade. All they knew was they were convicting him of the crime of petty theft. They had no idea as to what the sentence would be, and they were shocked to find that he's serving a sentence of 50 years to life. I was appointed to represent him in the Federal Court of Appeals, and my argument for him was a simple one. The 8th Amendment to the Constitution prohibits cruel and unusual punishment. Since early in the 20th century, the Supreme Court has said that excessive sentences are cruel and unusual punishment. If anything's cruel and unusual punishment, isn't it 50 years to life for stealing $153 worth of videotapes? As I said, nowhere else in the country could somebody receive the sentence. At the time he was sentenced in California, the maximum sentence for rape was 8 years in prison. The maximum sentence for second-degree murder was 15 years in prison. But his sentence for shoplifting was 50 years to life. Many things worked against him. He committed these crimes in San Bernardino, California. In San Francisco, Los Angeles, and San Diego counties, the district attorneys will not seek to use the 3 strikes law for petty theft with a prior. The San Bernardino district attorney does so. Also, there's no doubt that his race worked against him. Study after study has shown that if you hold all other variables constant, those who are Latino or African American are much more likely to receive the maximum charges and the maximum sentences. Andrade is Latino. I won in the Federal Court of Appeals. The court agreed with me that it's cruel and unusual punishment to impose a sentence of life without parole for 50 years for stealing $153 worth of videotapes. But to my surprise, the state of California, then Attorney General Bill Lockyer, sought review in the United States Supreme Court. I argued the case in November of 2002, and in the spring of 2003 I learned that I lost 5-4. Justice Sandra Day O'Connor wrote the opinion of the court, and she said there should be great deference given to states to decide punishments for crimes. Her opinion was joined by Chief Justice Rehnquist, Justice Antonin Scalia, Justice Anthony Kennedy, and Justice Clarence Thomas. Justice Stevens, in his dissent, made the point that I've now said to you a couple of times. No one in the history of this country had ever received a life sentence for shoplifting until California's three strikes law. At the time I argued the case, there were 362 individuals serving life in prison for shoplifting. The result of the Supreme Court's decision is that Andrade is not eligible for parole until the year 2046, when he'll be 87 years old. How did we get to the point in this country where there could be such an inhumane, such an important result? That's the story that I try to tell in my new book. From the time Richard Nixon ran for president in 1968, Republican presidents, candidates for the Republican nomination, have sought to change constitutional law in a conservative direction. The story I want to tell is how they've largely succeeded. It's easy to overlook the extent to which constitutional law has changed. The decisions come down one at a time. Roe versus Wade has never been overruled. Not every decision is conservative in outcome, but the overall picture is one that, from my perspective, is quite bleak. How did it happen? Well, between 1968 and 2009, Republican presidents got to appoint 12 nominees to the Supreme Court. Democratic presidents appointed only 2, Ruth Bader Ginsburg and Stephen Breyer. By historical accident, some of the Democratic presidents, most notably Jimmy Carter, got no nominees for the Supreme Court. He's only one of 2 presidents in history who didn't get to make nominees. But it's really not about Republican and Democrat. In my mind, it's really about conservative and liberal. Because, again, the reality is that some of the Republican nominees to the Supreme Court have been among the most conservative justices in all of American history. I think, for example, that Antonin Scalia and Clarence Thomas are as conservative as any justices, certainly since the mid-1930s. John Roberts and Samuel Alito, the picks of President George W. Bush, are everything that conservatives could have hoped for and liberals could have feared. This, of course, leaves Justice Anthony Kennedy on the current court as the swing justice. But he doesn't swing that much from side to side. Now, everyone knows that Anthony Kennedy is the pivotal justice on the court. I wrote a brief last year to the Supreme Court. It was a shameless attempt to pander to Anthony Kennedy. If I could have put Justice Kennedy's picture on the front of my brief, I would have done so. Anthony Kennedy, though, is a lifelong Republican. He was picked by President Ronald Reagan for the Supreme Court. When the court's ideologically divided, he's much more likely to side with the conservatives than with the liberals. Last year, for example, there were 12 5-4 decisions split along ideological lines. We had on one side Roberts, Scalia, Thomas, and Alito, and on the other, Stevens, Ginsburg, Breyer, and Sotomayor. Justice Kennedy sided with the conservatives in 9 and with the liberals in 3. The year before that, there were 16 cases ideologically divided, where you had Roberts, Scalia, Thomas, Alito on one side. That year was Stevens, Souter, Ginsburg, and Breyer on the other. Justice Kennedy sided with the conservatives in 11, with the liberals in 5. John Roberts has been Chief Justice for 5 years now. If you look at that half-decade, Justice Kennedy has sided with the conservatives in ideologically divided 5-4 cases significantly more than twice as often as with the liberals. So I decided that what I wanted to do was write a popular press book, a so-called trade book, about how conservatives have changed constitutional law. I write lots of things that no one ever reads, or a few law professors, but I thought it would be important to try to write in as accessible a way as I could about what's really happened in constitutional law. There are 6 major chapters to the book that look at particular areas. The first chapter is about American public schools are increasingly separate and unequal. By every measure, American schools each year become more racially segregated. Brown versus Board of Education in 1954 held that separate can never be equal in the realm of American public education. Yet, in the first decade after Brown, almost no desegregation occurred. In 1964, not one black child attended school with a white child in South Carolina, Alabama, or Mississippi. In other southern states, less than a fraction of 1% black or white children attended racially desegregated schools. But then, with the passage of the 1964 Civil Rights Act, with the Supreme Court saying that there had been all too much deliberation and not nearly enough speed, things began to change. And every year from 1968 to 1988 saw substantial progress towards desegregating American public schools. 22 years ago, that began to change. And every year since 1988, it has gotten worse, and it's getting worse at an accelerating rate. And it's not that the schools we have today are racially separate but equal. There's a tremendous gap in the funding of schools. A while ago, Harvard sociologist Christopher Jenks said 20% less is spent on the average black child's elementary and secondary schooling compared to the average white child's elementary and secondary schooling. Jonathan Kozol, in his stunning book, Savage Inequalities, presented the statistics in the middle part of the last decade. If you take any major metropolitan area, the predominantly white schools have significantly more than twice as much money as the predominantly black schools. I grew up in Chicago. Compare the funding of the Chicago public schools to, say, the New Trier or the Glenbrook schools. Here in California, despite California Supreme Court decisions to the contrary, compare the funding in, say, the Los Angeles Unified School District with the Beverly Hills School District. How did this come about? Well, there's many explanations, but part of the blame has to be put on the United States Supreme Court, and here especially the four justices of the court appointed by President Richard Nixon between 1969 and 1971. There were two decisions by the Supreme Court in the 1970s that I believe are especially responsible for there being separate, unequal schools. One was in 1973, a case called San Antonio Board of Education versus Rodriguez. In the San Antonio metropolitan area, there's tremendous difference between the amount spent on education between the poor, entirely Latino areas and the almost all-white affluent suburbs. And the issue before the Supreme Court was whether or not that disparity in school funding violates the Constitution. The Supreme Court, in a 5-4 decision, said that education is not a right under the United States Constitution. That may be a surprise to you. It's a holding that's never been overruled. There is no right to education under the Constitution. And the court said that disparity in school funding is thus constitutional. There are areas where the disparities are 10 or 20 times to 1 between what's spent for rich districts versus poor districts, wealthier kids versus poor kids. Now, I've heard critics say, how can you prove that expenditures really make a difference in education? And they point to studies that are inconclusive. But wouldn't we, as parents, all want to send our children to the districts where more is spent? Shouldn't poor kids have the same opportunity to be disappointed by the spending of money that wealthy kids have? Rodriguez was a 5-4 decision. Nixon appointee Lewis Powell wrote the majority. The other justices in the majority included Nixon appointees Warren Burger, Harry Blackmun, William Rehnquist, and an Eisenhower appointee, Potter Stewart. No doubt, had the case come down 5 years earlier, during the Warren era, it would have been different. Then the Supreme Court decided the next year, in 1974, a case called Milliken versus Bradley. It involved Detroit. The Detroit public schools were almost entirely minority students. But there were next door to them all white suburbs. So a judge said there's an easy solution here. Take some of the white students in the suburbs and bring them to Detroit. Take some of the black students from Detroit and bring them to the suburbs, often very short distances. And the Supreme Court in a 5-4 decision said such inter-district remedies are not permissible, that there can't be a transfer of students across district lines. Most big city school systems now are between 80 and 90%, if not more, minority students. It's true in Los Angeles, it's true in Chicago, true in Philadelphia, true in New York. Well, if you have a city school system that's 90% minority students, doesn't matter how you transfer the white students that are around, you're not going to achieve desegregation. These two cases created separate and unequal schools. The Supreme Court's only made it worse in recent years. 3 years ago, the court decided a case called, as parents involved in community schools for Seattle School District Number 1. It involved Seattle, Washington, and Louisville, Kentucky. Their popularly elected school boards adopted a policy of using race as one factor in assigning students to schools to achieve desegregation. The Supreme Court, in a 5-4 decision, declared this unconstitutional. The court was split along ideological lines. John Roberts was the Chief Justice and was writing for the court. He said school districts cannot use race as a factor to achieve desegregation. With the court limiting what lower courts can do, what school boards can do, we are at this point condemned to ever more having separate, unequal schools. If ever we will achieve equality in our society, it's going to be through education. And the Supreme Court is so closing those doors. The second chapter of the book focuses on the growth of presidential power. One of the points that I want to make in the book is that what's happened in recent years is a product of not just the Supreme Court, but also of the presidents and their policies. And it's not just this president or these justices, but it really traces back to Richard Nixon. In the early 1970s, Arthur Schlesinger, the noted Harvard historian, wrote a book titled The Imperial Presidency, about the great growth in presidential power, especially during the Nixon years. This increased with subsequent presidencies, but it came to fruition during the presidency of George W. Bush. It's interesting that there were some individuals who played a key role across these presidencies. Donald Rumsfeld and Dick Cheney played a key role in the Nixon administration, served as part of the Reagan administration, Cheney then as a congressman from Wyoming, and then were architects of the Bush foreign policy. During the Bush administration, for the first time in American history, the United States implemented policy of torturing individuals in violation of international law and domestic law. I don't know if you've had the chance to read yet. If not, I highly recommend Jane Mayer's book, The Dark Side, in which she documents how there was a conscious attempt to implement a policy of torture and how it was carried out. She tells one particularly chilling story of a man by the name of Khalid al-Masri. He was stopped at the German border. It was a case of mistaken identity. His name was on the list of somebody who was suspected of supporting terrorist activity. As Jane Mayer talks about, based entirely on suspicion of one person in the CIA, al-Masri was taken to a rendition camp. He was brutally tortured. He revealed no information because he had nothing to disclose. So the person the CIA ordered even more brutal torture. Finally, it was discovered that he had made a mistake, that the person the CIA was in error, that El-Masri was wrongly apprehended. He was then dumped on the streets of Albania. This isn't an isolated example. The Bush administration, unlike any before in American history, systematically implemented a policy of detaining individuals without due process in violation of the Constitution and national law. I begin this chapter by telling the story of Salim Garebi, a man who's been apprehended and held in Guantanamo Bay, Cuba, since the summer of 2002. I've been representing him since then. I can tell you in all honesty, without risking disclosing any confidential information, I don't know why Garebi is in Guantanamo, Cuba. He may be a very dangerous man and deserve to be locked up. Or, like so many, he might be there by mistake. He hasn't had any hearing. He hasn't had any trial. So how can we know whether he's there for just reasons or by error? The Bush administration implemented an unprecedented program of massive, warrantless electronic eavesdropping in violation of the Constitution and federal law. These abuses of power, I think, are not an accident. They're not a product of what occurred just over 8 years, but instead, I think they're the outgrowth of what occurred beginning in 1968 with the election of Richard Nixon, the growth of the imperialist presidency. The third chapter of the book talks about the crumbling wall separating church and state. It begins with the story of a collect phone call that I received from a man by the name of Thomas Van Orden. I'd never heard of Thomas Van Orden, but I always accept collect phone calls. And he said that he had brought a lawsuit challenging a Ten Commandments monument that sits at the corner of the Texas State Capitol and the Texas Supreme Court. The monument is 6 feet high and 3 feet wide. It has at the top in big letters, "I am the Lord thy God." And then it has the Protestant version of the Ten Commandments. One thing I later learned was that each of the major religions has their own separate version of the Ten Commandments, and there are significant differences. The Catholic version, for example, does not prohibit idols. The Jewish version talks about how God took the Jewish people out of bondage in Egypt. Well, this is the Protestant version. Van Orden said to me he had just lost his case in the Federal Court of Appeals, Texas, and would I take his case to the Supreme Court? I had not yet had a chance to read that Federal Court of Appeals decision, so I said, "I'll read the case and I'll call you back." To which he said, "I'm homeless and I don't have a telephone." Turns out that Van Orden was a graduate of Southern Methodist Law School. At some point he lost his law license. He became homeless. He spent a good deal of his time in the law library at the Texas Supreme Court. And he got tired every day of walking the monument that sits at the corner, and so he brought the lawsuit. He litigated it himself, did a great job, lost in the district court, lost in the Court of Appeals, and I agreed to take his case to the United States Supreme Court. The court granted review, and I lost 5-4. Chief Justice Rehnquist wrote the opinion for the court, his last opinion that William Rehnquist wrote before his death. In 1947, all 9 justices said that the best way to understand the provision of the First Amendment, which prohibits establishment of religion, is to see it through the metaphor coined by Thomas Jefferson. There should be a wall that separates church and state, a wall high and impregnable. How could it be, then, that the Supreme Court would allow a 6-foot-high, 3-foot-wide Ten Commandments monument literally at the corner of the Texas Supreme Court and the Texas State Capitol? Well, over the last several decades, conservatives have vehemently disagreed with the notion of a wall separating church and state. At the oral argument in the Supreme Court, Justice Anthony Kennedy said to me, "If your client doesn't like the Ten Commandments monument, why doesn't he just look the other way?" And I responded, there's no stopping point to that. The government shouldn't be able to do something unconstitutional and say, it's okay, if people don't look. And by that reasoning, a city could put a large Latin cross atop City Hall and say, it's fine, just don't look at it if you don't like it. Chief Justice Rehnquist took the view that the government violates the Establishment Clause of the First Amendment only if it literally establishes a church or coerces religious participation. By this view, very little will violate the Establishment Clause. The government's not going to create formal churches. So much of what usually violates the Establishment Clause doesn't coerce religious participation. I think there are now 5 votes on the current court, Roberts, Scalia, Kennedy, Thomas, and Alito, to take this view that the government only violates the Establishment Clause if it creates a church or coerces religious participation. So, assuming this prediction is right, the government can put any religious symbols it wants anywhere on government property, be they Ten Commandments monuments, nativity scenes, crosses, menorahs. The government will be able to give any aid it wants to religious schools, including for religious indoctrination, and much more of a religious presence will be allowed in public schools. Here I think this traces back to Ronald Reagan, his advocacy for a constitutional amendment to allow prayer in public schools, and especially the justices he put on the court. The 4th chapter of the book talks about the vanishing rights of criminal defendants. It begins with a story of a man by the name of Philip Wilkinson, who I represented. Wilkinson committed a heinous crime. He murdered 3 people. He did so while he was in the Army. He was honorably discharged. He went home to Wyoming. And then, a year later, even though he was not in any way a suspect in the crime, he went back to North Carolina, where he'd been stationed at the time, and he confessed to these 3 killings. His lawyer in Fayetteville, North Carolina, I was told by somebody else, was somebody you wouldn't want to represent you if you had traffic tickets. I've read the transcript of the trial, especially the penalty phase, and he couldn't have had worse representation. Let me give you some examples. When Wilkinson decided to plead guilty, he had the minister from his church come with him. And the minister regularly talked to him while he was in jail in North Carolina. A key factor in arguing against the death penalty is remorse. I think this would work very well for Wilkinson. He, on his own, came forward and confessed. He had the minister who would testify about his remorse. But the trial lawyer didn't call the minister as a witness. And the minister showed up on his own and said, I'll testify about his remorse. And the trial lawyer said, no, we don't need you. The trial lawyer didn't call Wilkinson's parents to testify. Now it's important because abuse during childhood, both mental and physical, the Supreme Court said is an important mitigating factor. And in many ways, Wilkinson was abused as a child. Wilkinson's mother got in touch with the lawyer and said, we want to come testify, not get the death penalty. And the lawyer said, oh, we don't have any resources to bring you to North Carolina. North Carolina has a statute that specifically says that the state will pay to bring witnesses in to the penalty phase of a death penalty case. I go on with examples. There's no doubt that this was, by any measure, deficient performance of counsel. In fact, at the oral argument, one of the judges in the 4th Circuit said to the attorney for North Carolina, how do you explain not calling the minister as a witness? And the attorney for North Carolina said, strategic choice by the counsel. And the judge said, well, explain the strategic choice. And she was silent. And then the same judge said to her, how do you explain not calling the boy's mother as a witness? And she said, strategic choice by counsel. And then the judge, getting exasperated, said, but this was a Southern jury. They'd want to hear from the boy's mama. I lost 3-0 in the case. The Supreme Court denied review. The 4th Circuit said, even though counsel's performance was clearly deficient, we can't say that the jury would have come to a different conclusion had they heard the testimony. There's no way to know that. I did some research and I discovered, at least as of that time, there was no case in which the United States Court of Appeals for the 4th Circuit the Federal Court of Appeals that covers that part of the country, had ever found counsel's performance to be prejudicial and to overturn a sentence based on ineffective assistance of counsel. Former colleague of mine, now a Yale law professor, Denny Curtis, said that the measure for effective assistance of counsel is if you held a mirror in front of the mouth of the defense counsel at trial, would you have seen a breath? Professor Curtis exaggerates, though there was one case in Texas where, in a death penalty matter, the trial lawyer slept through much of the case. And the Federal Court of Appeals said it was not ineffective assistance of counsel, and I'm quoting here, because it could not be shown that the trial lawyer slept through important parts of the trial. Thankfully, the entire Federal Court of Appeals overruled that. But what I try to show in this chapter is that the erosion of the rights of criminal defendants affect all of us. All of our privacy is lessened when the Supreme Court decreases the protections of the Fourth Amendment. The chances of imprisoning or even executing an innocent person grow tremendously when we lessen the protections that the Constitution provides. The fifth chapter talks about the lessening of individual freedom. For me, it was the hardest of all the chapters to write. All the other chapters begin with a story of a case that I argued, usually in the Supreme Court, sometimes like the Wilkinson case in the Federal Court of Appeals. This chapter actually begins with the story of my father's death. In the spring of 1993, my dad was dying of lung cancer. He was in the hospital in northwest Indiana where he lived, and he knew he was never going to get out of that hospital bed. He was in terrible pain whenever he was conscious. The cancer had spread and caused a tumor that blocked circulation to his arm. Gangrene had formed in the arm. It was grotesquely swollen. He saw no point in having the arm amputated. He knew that only days, week at most, to live. It didn't matter at that stage whether it was the gangrene or the cancer that killed him. Late on a Monday afternoon, the doctor came to see him in his hospital bed. My dad asked him if he could just give him a little bit extra morphine to end his life. My dad said that either he was in terrible pain or sedated unconsciousness. The doctor very brusquely said to him, no. My dad, till the end, was incredibly persistent and raised it again, and the doctor literally turned his back on my father and walked out of the room. My dad died 4 days later on the Friday afternoon. I will never understand what interest the state of Indiana had in keeping my father alive those 4 days and denying him death with dignity. The reason it fits into the book is that the question comes to constitutional law. Is there a constitutional right to physician-assisted death? And the Supreme Court, it was functionally a 5-4 decision, rejected such a right. Chief Justice Rehnquist wrote for the court. The same conservative justices, O'Connor, Scalia, Kennedy, and Thomas, comprised the majority. The Supreme Court has long said that privacy is a fundamental right under the Constitution. If privacy means anything, shouldn't it be the right of a terminally ill patient to have death with dignity? What I try to argue in this chapter is that the Supreme Court's recognition of this right is consistent with what's gone on for several decades, in the Supreme Court narrowing rights and also rejecting new rights. Since Roe v. Wade was decided in 1973, the Supreme Court has not recognized any additional right is fundamental. The closest you can come to a new fundamental right is the Supreme Court in 2008 and again in 2010 saying that the Second Amendment protects the right of individuals to have guns apart from malicious service. From 1791, when the Second Amendment was ratified, until June 26, 2008, no Supreme Court decision had ever protected the right of individuals to have guns. The Supreme Court had always said the Second Amendment was about a right to have guns for militia service. That's what it says. It says a well-regulated militia, being necessary to a free state, the right of the people to keep and bear arms shall not be infringed. But in 254 decisions, the Supreme Court has said that the Second Amendment does protect the right of individuals to have guns. It's interesting. The one new right recognized, the one right that seems to be reaching the stage of being fundamental, is the one that does fit within conservative ideology. The 6th chapter of the book is titled Closing the Courthouse Doors. And I begin here by talking of two of my clients who will be most well known to you, Valerie Plame and Joe Wilson. In fact, there's now a movie about their story, Fair Game, with Naomi Watts and Sean Penn. Everyone's familiar with the story. President Bush, in his State of the Union address, said that Iraq was trying to buy uranium from Africa. Previously, a former ambassador, Joseph Wilson, had been sent to Africa to investigate and came back and reported that there was no evidence whatsoever that Iraq was trying to do this. After President Bush said the contrary in his State of the Union address, Joe Wilson in June, in an op-ed piece in the New York Times and then in statements on Meet the Press, said that the president had not been telling the truth. At this point, Vice President Dick Cheney, aides Louis Libby, Karl Rove, Richard Armitage, engaged in a systematic effort to reveal that Valerie Plame was a CIA agent. As was said to Chris Matthews from Hardball, quote, she's now fair game, which where the title of her autobiography in the movie comes from. I filed a lawsuit in a federal court in Washington, D.C. on behalf of Joe and Valerie. I claimed that Joe Wilson's First Amendment rights were violated because he was being punished for his speech by destroying his wife's career, and also that for both Joe and Valerie, their privacy was invaded by disclosing this. Also, Valerie's career was ruined. You can't be a secret operative anymore when it's disclosed that you're a secret agent. The judge assigned to the case was a very conservative judge and appointed to the bench by President George W. Bush, John Bates. And he said that the lawsuit should be dismissed because there's a statute, the Privacy Act, that can provide a remedy. Well, it's strange to think that constitutional claims can't go forward because there's a federal statute. But the problem's even greater than that. Joe Wilson didn't have any information disclosed to him, so he has no claim under the Privacy Act. The law is clear. You can only bring a claim under the Privacy Act if something about you has been revealed. But also, the Supreme Court had previously held that the Privacy Act doesn't apply to the office of the President and Vice President. So Cheney, Rove, and Libby aren't covered by it. How can a statute that doesn't apply preclude constitutional claims? The only other thing that Judge Bates said was that the suit should be dismissed because it's going forward might reveal secret information. Now, the analogy I gave in my brief, and I use this in every brief I filed in the case, is this is truly the example of the child who kills his parents and pleads for mercy for being an orphan. It's the defendants who revealed the secret information. Besides that, after the Louis Libby trial for perjury, I don't think that anything was secret. And maybe down the road in this litigation, something secret might come out, but no reason to dismiss the case there. The D.C. Circuit, in a 2-to-1 decision with 2 conservative judges in the majority, 1 liberal judge dissenting, affirmed. And on June 22nd of 2009, the Supreme Court denied review. So Joe and Valerie will never have their case go forward. It was dismissed at the earliest stage. And what I try to tell in this chapter is how the Supreme Court, in so many doctrines, has closed the courthouse door to those with meritorious claims. In some ways, this is the most insidious of the things I talk about in the book, because it doesn't make headlines in the newspaper. If the Supreme Court throws a case out because of lack of standing or because of sovereign immunity, people don't pay attention to it. It seems technical, procedural. But one way in which our rights are undermined if courts aren't available to vindicate them. Let me give you one example that's much easier to relate to here. The tremendous effort by the Supreme Court to shift cases out of court to arbitration. Not long ago, I went to a new eye doctor for the first time. And before being seen, I had to fill out a sheaf of papers. And in one of them, I was asked to sign a statement that said that if I had any claims against the doctor, I was waiving my right to go to court, and I would have to go to arbitration. Maybe you've seen similar forms. Many of you are nodding around the room. So I said to the receptionist, if I don't sign, will the doctor still see me? And she said, I don't know. Nobody's ever asked that question before. Doctors, insurance companies, employers, businesses want you to go to arbitration, not to go before a jury. And the Supreme Court has done so much to further this. I'll give you just one example. Last year, there was a Supreme Court case called Rent-A-Car versus Jackson, June 2010. Came out too late to be included in the book. It involved a man who applied for a job in a rent-a-car company. And he filled out the application for employment. He didn't notice that in the small print in the application it said, if he had any claims against the company ever, they would go to arbitration and not go to court. Well, later he brought a discrimination claim against the company, filed it in court, and the company said, no, he signed a statement. It was the small print there when he filled out the application. They would go to arbitration and not to court. Well, I thought he had a very strong argument. He didn't really ever agree to that. It was the fine print. There's a long-standing principle that so-called unconscionable contracts, contracts where there's not a bargain for exchange, aren't enforceable. And the question is, who should decide that? Should the arbiter get to decide that? Or the judge get to decide it? 5-4, the Supreme Court said the arbiter gets to decide whether or not it goes to arbitration. Justice Scalia wrote for the court, joined by Roberts, Kennedy, Thomas, and Alito. This is just one of many examples of closing the courthouse door. The concluding chapter of the book starts with the story of Bush versus Gore, and my going down to Florida to argue the case of the butterfly ballot. The point that I want to make is that for decades, conservatives have railed against liberal judicial activism. I think judicial activism is a phrase that has no meaning. It's just a label we use for the decisions we don't like. But the reality is that the activism of the last few decades has been very much in a conservative direction. And despite all of this, I then conclude the book on what I regard as an optimistic note. If you look at the sweep of American history, there's been tremendous growth in equality and freedom. We've gone from a society with the incomprehensible, abhorrent practice of slavery to one with Jim Crow laws, to ones with civil rights statutes, to one where, at least in some places, sometimes, there's affirmative action. Women have gone from being chattels, literally property of their husbands, to finally getting the right to vote, to at least a move towards equality. In the last decade, there's been a great growth in the move towards equality for gays and lesbians. Freedom is similarly expanded. And I believe that that will be the course of American history. I just think that these couple of decades will be regarded as a time of regression. So I've talked for my allotted time. Now I'm glad to take your questions. And that's the book. Thank you. I'll repeat the questions. Oh. Go ahead.
Please talk about Citizens United, which didn't get in the book.
It is.
And we'll go back to the 1893 decision that started to give corporations their rights of people.
The question is about Citizens United and the 1893 decision that gives corporations rights of people. The manuscript was completed at the end of December vacation last year, but then I was, thankfully, as Rafe knows so well, you get chances in the editing process and the galley stage, and so I was able to include some discussion of Citizens United. As everyone knows, in Citizens United versus Federal Election Commission, decided January 21st, 2010, the Supreme Court held that I didn't do it. Maybe that's the spirit of John Roberts. In Citizens United versus Federal Election Commission, the Supreme Court said that corporations and unions have the First Amendment right to spend as much as they want independent expenditures to get candidates elected or candidates they oppose defeated. I think this is one of the most important Supreme Court cases in recent years. What will it mean for our political system when corporations and unions can spend as much as they want to get candidates elected or candidates defeated? I think when the analysis is done of the November 2010 elections, from week to Tuesday, I think we will see the effect of Citizens United. I worry especially what it's going to mean for judicial elections in states with elected judges, as the money is coming from the interests that go before the court. I worry in small towns where one corporation can truly drown out other voices. I also think that it so illustrates the point that I was making to you about what does judicial activism mean? If I were to come up with some neutral definition of judicial activism, I'd say, well, the court's being active if it's overruling precedent, restrained if it's following precedent. The court is active if it's declaring laws unconstitutional, restrained if it's upholding them. The court is being active if it rules broadly, restrained if it rules narrowly. Now, let me be clear, that's just descriptive. It's not evaluative or normative. Brown versus Board of Education, by this definition, was judicial activism. The court overruled a 58-year-old precedent. The court struck down laws throughout the country. The court ruled broadly. But we regard Brown as the epitome of why we have the federal judiciary and the Supreme Court. But from this perspective, Citizens United was very much judicial activism. The court struck down a provision of a federal statute that had been adopted almost unanimously by Congress in 2001 and signed by President Bush. The court overruled the 2003 decision that upheld the provision. And the court reached an issue that hadn't been briefed or argued as to whether or not these earlier decisions should be overruled. Citizens United, the bottom line is that corporations, and by implication unions, can spend as much as they want in election campaigns. The other part of your question was about corporations being persons and having rights under the Constitution. You're right, that traces to 1893, and the Supreme Court is very inconsistent about this. Corporations cannot claim the privilege against self-incrimination under the Fifth Amendment. They do not have privacy rights under the Fourth Amendment. But since 1978, they've had speech rights under the First Amendment. I don't expect the Supreme Court's going to give corporations the right to vote or the right to marry, but maybe that's about mergers and acquisitions. I don't know. Can they run for office?
Question over here.
Please. Do you foresee the possibility of the President being able to fill another Supreme Court position, specifically Justice Kennedy?
Let me tell you the current age of some of the justices. The oldest justice now in the court is Ruth Bader Ginsburg. She's 77 years old. Perhaps because she's frail in appearance, there's always speculation that she might step down. I've known her well since the early 1980s. She's been frail in appearance all of this time. So I don't read too much into that. But she is 77, and there's always rumors she might retire from the court. In terms of the other justices, on the more liberal side, Elena Kagan is 50. Sonia Sotomayor is 56. Stephen Breyer is 73. Now I'll tell you about the more conservative side. John Roberts turned 55 in January of this year. If he remains on the Supreme Court until he's 90, the age at which Justice Stevens retired, he'll be Chief Justice until 2045. Samuel Alito turned 60 on April 1st of this year. Clarence Thomas has been on the Supreme Court 19 years, but he's only 62 years old. Both Antonin Scalia and Anthony Kennedy are 74 years old. I think the best predictor of a long lifespan is being confirmed for a seat on the United States Supreme Court. I don't expect that any of these five justices, Roberts, Scalia, Kennedy, Thomas, Alito, will be leaving between now and January 20th, 2013, or even if there's a second Obama term between now and January 20th, 2017. The vacancies for President Obama to fill are Souter and Stevens and perhaps Ginsburg. That's not going to change the overall ideology of the court.
Over here.
Yes.
Please use the mic if you're going to ask a question.
Legally, the issue of the write-in votes in Alaska, do you think it should come down to the correct spelling of the name, or how would that be spelled?
I think everyone saw the article in yesterday's papers that Joe Miller, the Republican candidate for Senate, is in a write-in battle. Was on the ballot, but Lisa Murkowski, the incumbent, is a write-in. And Joe Miller is saying that unless Murkowski was spelled exactly correctly, the vote can't count. Given my last name, I am not at all sympathetic to Miller's argument. Actually, the standard is the intent of the voter. So long as it would be intelligibly read as Murkowski, even if you didn't get every letter correct, it has to be counted that way. To say it has to be spelled perfectly would be a silly standard. And it also would favor people with last names like Miller over those of Murkowski. I'm letting them call on.
Has the people ever brought a suit against Congress passing certain laws? And the reason I'm asking the question is because in January, a couple of years ago, they passed a law entitled Dumb the Public. And I think that's horrible because they based it on the fact that the public doesn't need to be confused by certain things. And it was a very general law that Congress passed. And so that's why I was wondering if Congress does something like that, is there any...
I don't know if that's statute, but let me answer your question more generally. If a law is passed that's unconstitutional, a person who is injured by the law can bring a lawsuit saying it's unconstitutional. Congress is an entity, though, cannot be sued. The United States government generally can't be sued because there's a principle called sovereign immunity that says that the United States government can be sued only if it consents to be sued. And this comes, no, I'm not making this, it comes from English law. It actually comes from a principle that the king can do no wrong. And we inherited it in American law. One of the things that I actually talk about in chapter 6 of the book is the growth and expansion in sovereign immunity over the last 15 years in the Supreme Court. So the answer to your question is, if the law is unconstitutional and somebody's injured by it, they can bring a lawsuit to challenge that law and have it declared unconstitutional. But you can't sue Congress virtually ever. And you can't sue members of Congress for what they've done almost ever.
Over here.
I'm wondering if you see if you can sort of see the future for what's going to happen with campaign finance. I mean, after Citizens United, it sort of brings up an interesting tension with the sort of original big campaign finance decision in Buckley and decisions since then. It's a very odd landscape where the court is telling us that they are not going to strike down laws passed, but they are. So I wanted to get a sense of where campaign finance regulation goes from here.
Sure. As you rightly point out, the key case with regard to campaign finance was a 1976 decision, Buckley versus Vallejo, which involved amendments to the Federal Election Act that were adopted in 1974 after the exposure of all the aspects of the Watergate scandal. In Buckley versus Vallejo, the Supreme Court drew a distinction between independent expenditures, what somebody spends on his or own on behalf of a candidate, and contributions directly to a candidate or committee for a candidate. And the Supreme Court said the government can't limit independent expenditures, but the government can limit the amount that's contributed directly to a candidate or committee for a candidate. To make this concrete and not abstract, imagine that somebody had $1 million in 2008 to spend for McCain or for Obama. Buckley v. Vallejo says the government can limit the amount of the contribution directly to the candidate or committee for candidates, saying you can't give more than $1,000 to the candidate. But the government can't stop the person from spending $1 million overall. The government can't stop the person from taking out ads directly. One part of the law that was struck down in Buckley said that a candidate for federal elective office can't spend more than $25,000 on behalf of his or her own campaign. And this says if you're a millionaire or a billionaire, you can spend, hypothetically, $150 million to run for governor. It's an aside, but my favorite political cartoon I've seen recently was in one of the Sunday papers last week. And it had Meg Whitman sitting before a computer terminal. You know, she made her fortune at eBay. And it has the caption saying, "I thought that it goes to the highest bidder." Buckley says the government can't limit, not in local elections, not in state elections, not federal, expenditures, but the government can limit contributions. Citizens United involved a federal law that said the corporations and unions can't engage in certain independent expenditures. And the Supreme Court in Citizens United said restrictions on expenditures for corporations or unions, as for individuals, are unconstitutional. I think the key issue in response to your question is, will the Supreme Court allow contribution limits to stand? For example, in 1907, Congress passed a law that said that corporations cannot contribute money to candidates for federal elective office. In 1946, this was extended to unions. I think there are now 5 votes on the Supreme Court to hold that all contribution limits are unconstitutional, including those for corporations and unions. This is a position that Justice Scalia, Kennedy, and Thomas have long taken. I think they've now got Roberts and Alito to join them on that. And then what will it mean when corporations can contribute as much as they want directly to candidates, or rich people contribute as much as they want directly to candidates? I worry then about corruption, the appearance of corruption, when there's the large, unlimited direct contributions. And I think that's where I think the law is going to go. I think once the Supreme Court, once the Supreme Court says that corporations have the same free speech rights as individuals, and once the court says spending money in elections is core political speech, I don't see how the court's going to come up with any other conclusion. Please. Over here.
Some of the settlements in the medical field for malpractice and whatnot is, so they say, is driving rates higher. And you seem to be against arbitration, at least in some cases. Do you have some thoughts on tort reform that would perhaps do away with some of these huge settlements?
What I think, I'd strongly encourage, there's actually a large body of literature about this. And what it shows is the large settlements are not very frequent. The large jury awards are not very frequent. And there's some wonderful responses that have been done that actually look at the data. I'll tell you, I think, he's done some of the best work, and if you just Google his name, you can find it. It's a man named Neil Vidmar, V-I-D-M-A-R, who's a professor at Duke, who's actually done an analysis of the punitive damage awards and large damage awards in the medical malpractice field. I think there's a real danger in reasoning from anecdote here. You know, we've all heard the woman who spilled the hot coffee from McDonald's and got the large judgment, and then we generalize from that. And it is important to look at the studies. In a Supreme Court decision involving the Exxon Valdez case a few years ago, Justice Souter, writing for the court, reviewed all the literature about punitive damages and found that the large punitive damage award is really the anomaly. And I think that's what you'd find was the large award in the medical malpractice area as well. I know it's very contested, and the best I can say is you should look at both sides of the data and come to your own conclusion.
Well, first of all, I'd like to say thank you for coming out on behalf of Cal State Fullerton's undergraduate core team. And as far as the Affordable Health Care Act goes, the individual mandate by Congress, is that constitutional, and is inactivity a part of Congress's Congress clause authority?
I'm always reluctant to make predictions about what the Supreme Court's going to do. I long ago learned that he who lives by the crystal ball has to learn to eat ground glass. But here I feel confident in a prediction. I think the Supreme Court will uphold the constitutionality of the individual mandate in the federal health care plan. I am not saying whether it's desirable or undesirable legislation. I'm not saying it's good or bad. Health care is not my field. I'm talking about constitutionality. And I actually think it's a clear question there. And I feel bolstered in this by Charles Freed, who's a very conservative law professor at Harvard. He was the Solicitor General of the United States during the first Bush presidency, said he doesn't think it's a close question, that it's constitutional. Why? Well, I don't think there's a plausible claim that people have a constitutional right not to buy health insurance. The Supreme Court has said since 1937 that the government can regulate economic transactions so long as the government's acting reasonably. It's reasonable to require everyone to have health insurance or pay the cost of that. Everyone's going to need medical care at some point in his or her life. Children are required by law to have vaccinations before going to school. If somebody has a communicable disease, the government can require it to be treated. If somebody's in an automobile accident, they're going to be taken to the local emergency room and given treatment. The real constitutional question is the one you raise. Does this fit within the scope of Congress's powers? Congress can act only if it can point to authority in the Constitution. There are two powers that are relevant here. One is the one that you spoke of. Article 1, Section 8 gives Congress the authority to regulate commerce among the states. The Supreme Court has said this means that Congress can regulate any activity which looked accumulated across the country has a substantial effect on interstate commerce. The last Supreme Court case about this was in 2005, Gonzalez versus Raich. Angela Raich was undergoing chemotherapy. She was growing marijuana plants at home to offset the ill effects of the chemotherapy. And she brought a lawsuit arguing that Congress lacked the authority under the Commerce Clause to criminally punish private cultivation and possession of marijuana for personal medicinal use. The Supreme Court, in a 6-3 decision, upheld the federal law and ruled against Raich. Even Justice Scalia was part of that majority. The Supreme Court said that growing marijuana is a crop that's bought and sold in interstate commerce, albeit illegally, and that therefore growing it is economic activity, and looked at cumulative across the country the substantial effect on interstate commerce. If Angela Raich growing marijuana for her own personal use can be regulated by Congress, then certainly $1 trillion industry can be regulated by Congress under its Commerce Clause authority. Unless the Supreme Court wants to unravel so much of post-1937 constitutional law, I don't see how they could strike this down. But there's even an alternative argument. The government says that what the law does is say either you purchase health insurance or you have to pay a tax. The Supreme Court has not declared any tax to be unconstitutional since the mid-1930s. I think it would be very hard to find it unconstitutional. Now, Rafe, in the introduction, mentioned that there are several people from the Pre-Law Society. He and I were talking that we would love to have the Pre-Law Society come see UCI Law School. And so let's just arrange a time, and we'll give you a tour. You can meet our admissions staff. And I'm glad to answer any questions you have about law schools other than about UCI, too.
Right here. He's got the mic.
My name is Larry Pollicott, and I'm speaking for a criminal attorney. I've been very honored for years by our criminal justice system. And the attorney told me that he was instructed to defend a criminal with limbs, which might mean... Excuse me. The criminal attorney was instructed in school to defend a criminal with vehemence. Does that mean that they should leave the criminal? They should try to get him off at all means? If somebody was going to try to blow up Chicago, should they try to get this person off? Or should the punishment fit the crime?
Well, the punishment should fit the crime. And if somebody committed the crime, I hope they'll be convicted and they'll be punished appropriately. You raised the question of what's the role of the criminal defendant. And actually what the law says here is that a criminal defense lawyer is to defend the client within the bounds of the law. That you're supposed to zealously represent your client, but within the bounds of the law. So you don't lie on behalf of your criminal defendant. You don't put false testimony on the stand on behalf of the criminal defendant. You don't fabricate documents on behalf of the criminal defendant, but you defend the person in the bounds of the law. I have no problem representing those who I believe are guilty, And the reason is, I believe that the only way we can protect the innocent is to make sure that the state always has to prove its case beyond a reasonable doubt. I don't want the lawyer to be the judge. I want the judge to be the judge. I want the jury to be the jury. And so all the criminal defense lawyers there to do is make sure that no matter what the person is accused of, that the prosecutor has to prove beyond a reasonable doubt that the crime has been committed. We now know, thanks to the work of the Innocence Projects, I think it's now over 125 innocent individuals who were sentenced to death. If you haven't read it, I highly recommend John Grisham's book, An Innocent Man. It's a non-fiction book, and it tells the story of how an innocent person was convicted and almost put to death. How do we avoid that? Well, one way is by making sure that everybody accused of a crime has zealous representation. And even if I think my client is guilty, and even if it's a horrible crime, I still should give them zealous representation, but within the bounds of the law. I wouldn't say vehement representation. I'm not sure what that means. Zealous within the bounds of the law are actually the rules, the words that are used in the rules of ethics.
My husband, who's a law student and loves reading Supreme Court rulings, thinks that Roe v. Wade was not a very well-written decision, and really was more the leanings of the court at the time. And I was wondering if you agreed and whether you thought it might be overturned by the current court.
I disagree, and actually one of the things that I do in Chapter 5 of the book is explain why I disagree. The quick answer is, the Supreme Court has said since the early 1920s that privacy is a fundamental right under the Constitution, even though it's not mentioned. And the Supreme Court is protected under the right to privacy, including the following: the right to marry is a fundamental right, the right to procreate, the right to custody of one's children, the right to keep the family together, the right to control the upbringing of one's children, the right to purchase and use contraceptives. All of those from decisions before Roe v. Wade. So the question before the Supreme Court was first, does a law that prohibits abortion infringe a woman's right to privacy? And I think the answer to that is clear. Forcing a woman to continue a pregnancy to term against her will is an intrusion on her ability to control her body, whether to bear or beget a child. Then the second question is, does the state have a compelling interest in protecting the fetus from the moment of conception? What the Supreme Court said here, and I can quote you Justice Blackmun's exact words, is there's no consensus in our society as to when human personhood begins. Some believe that human personhood begins, and we focus on person because that's a word in the Constitution, at the moment of conception. Some believe that it begins at the time at which the embryo takes on individual characteristics. Some believe that it begins when the embryo implants in the uterine wall. Traditionally, the law has regarded human person as beginning at quickening, when the woman feels the first movement of the fetus. Another point, which what Roe v. Wade said, was viability, the time at which the fetus can survive outside the womb. Some religions regard person as beginning at birth. I think law students, including your husband, may regard personhood begins when you graduate from law school. What the Supreme Court said was that it's not for the court to make that arbitrary choice. Once the fetus can survive, then the state has the interest. That's viability. But until then, let each woman decide for herself. If a woman doesn't believe in abortion, of course, then she shouldn't have one. But if a woman does believe in abortion, it violates her privacy rights to compel her to carry the pregnancy to term. Now, you may strongly disagree with this, but I think in terms of constitutional reasoning, I do think it's a well-reasoned opinion. And I try to defend it in the book, but that's the basic outline of the argument.
I want to ask you this. What is your stand on don't ask, don't tell?
Don't ask, don't tell.
I don't understand, and I wrote this, I had an op-ed in the LA Times just a couple of weeks ago about this. I don't understand why the Obama administration has chosen to appeal here. The president has said that he wants don't ask, don't tell to be ended. The federal district court judge in Riverside, Virginia Phillips, has issued a nationwide injunction. That ends. Don't ask, don't tell. If there's no appeal, it's all over. Every study, well, I guess I should go back. Judge Phillips held a trial, and she asked for evidence in terms of proof that don't ask, don't tell helps the military, that allowing gays and lesbians to serve openly in the military in any way is harmful to the military. No evidence was introduced whatsoever in her court to support that. She recites in great detail all of the evidence shows don't ask, don't tell doesn't have any positive effect in the military. Then all of a sudden, after the decision comes down, the Secretary of Defense and Undersecretary of Defense saying it will cause irreparable injury to the military to allow openly gay and openly lesbian individuals to serve. There's no evidence to support that. Here I'm just focusing on the proof in court that was presented. I wish the Obama administration had chosen not to appeal. Congress is considering repealing Don't Ask, Don't Tell. There was a Republican filibuster in the Senate that prevented this from going through before the election. I don't know if there's more chance of going through now. I think the reality is Don't Ask, Don't Tell is going to be repealed. It's going to be regarded as a relic of another time. I think the question is, will it come through this lawsuit or will it come through Congress and when?
Another lawsuit over here.
Okay.
That's actually a fantastic precursor to this question. Do you think that the fundamental right to privacy encompasses a right to same-sex marriage?
Yes. Wow. The real question, though, is not what I think. I mean, the real question is, what's the Supreme Court going to say in answer to your question? And it's tempting, in light of what I said earlier this morning, to simply now say, it's going to be a 5-4 decision and Justice Kennedy is going to be in the majority. But I actually believe the Supreme Court is going to say that, as Judge Walker did in San Francisco, that gays and lesbians have the same right to express love and commitment, to get benefits that the law provides to married couples, to experience the disappointments of marriage that heterosexuals have always had. What's so striking to me is the lack of a legitimate government interest in keeping gays and lesbians from being able to marry. Who's hurt by gays and lesbians being able to marry? I remember going on a radio program after the day of Judge Walker's decision, a conservative radio talk show, saying that Judge Walker's decision damages marriages in California. And I went home to my wife and I said, is our marriage hurt at all by that? I've heard, let me just finish the answer real quickly. Let me finish real quickly. The main argument that opponents of same-sex marriage give is for children, that marriage is about procreation. If you read the brief that's been filed in the Federal Court of Appeals, well, first, heterosexual couples can marry even if they're incapable or don't want to have children. But beyond that, gay and lesbian couples will have children whether or not they can marry. Lesbian couples through artificial insemination, adoption, gay couples through surrogacy and adoption. If you believe that marriage is good for children because it provides stability, then wouldn't it be good for those children to allow marriage? I know there are some who feel very strongly against this. You might have seen that just a week ago Tuesday, 3 justices on the Iowa Supreme Court were denied retention because they were part of a unanimous decision to find a right to gay and lesbian marriage. Though I guess my answer, and I apologize if it's flippant, is for those who are against gay marriage, they shouldn't marry somebody of the same sex. But that doesn't mean that gays and lesbians should be denied this. Last question.
One more question.
Yes, as kind of a follow-up to that question, it seems to me that one of the arguments that I don't hear very often is that in requiring states to allow gays and lesbians to marry, essentially the word marriage is redefined, at least for many of us who've been married 30 years plus. Years ago, it was understood that when you got married, it was going to be of someone of the opposite sex. It just feels to me, and I know it's politically unpopular, but it feels to me that marriage in itself has one meaning, as a man and a woman. Now,
Sure, no, I understand the question. I'm so glad you raised the question. Here's the problem with that. from the time the Constitution was written until 1967, in southern states, interracial marriage was prohibited. It wasn't until 1967 that the Supreme Court declared unconstitutional the Virginia anti-miscegenation law. So marriage in those states was defined all of that time as marrying somebody of your race. That was declared unconstitutional, and those states had to accept that marriage could include marrying somebody of a different race. Well, you're right that up until 2003 in the United States, marriage was always between a man and a woman. But the question we have to think about is that the core characteristic of marriage? Or is the core characteristic of marriage the expression of love and commitment recognized by the law and with benefits that only married couples can get? And my view of it is, as I said in response to the prior question, I think that's what marriage is about. Marriage is expressing love and commitment in a manner recognized by law and then getting benefits that law provides. If so, then I think that gay and lesbian couples should have that same ability, and their children should have the benefits that marriage provides to family, and we should expand it just as the court expanded it in a racial way in the 1960s.
Obviously, I want to thank Erwin Chemerinsky for a fantastic presentation and for taking all of our questions. I have a couple of just announcements and a few more introductions, which is you may have picked up that there's two student law groups here today. There's the Pre-Law Society and our Moot Court team, which is, and the Pre-Law Society, where's Max Geary is our advisor, and Pam Fiber-Ostro is our advisor for the Moot Court. Our Moot Court team, by the way, has been defeating schools that have been doing this stuff for years, and I say, what's that school in Virginia? Patrick Henry, we're breathing down your neck. We're going to be like the baseball team. We're going to talk to it and say, hey, you got to figure that out. So, thanks to all of our students for being here, and you did hear the invitation from Dean Chemerinsky. We're going to take him up on that, and we're going to go down there and have a Cal State Fullerton Day. At this point, we're right on schedule. I know a number of you have already bought Erwin's book. There's more copies for sale. We have a small room over there where he'll be signing books. The price of admission is his book. It's a small room, but he has to leave campus right at 12:30 because he's got to be back at Irvine for a meeting at 1 o'clock. He came here from a meeting to get here right at 10. I think he had a 9 o'clock meeting and a 1 o'clock meeting. And we're going to keep him right on schedule. Dick Blake, thank you again for everything. And Ollie, thank you for your participation.